everyone, and welcome back to another episode in Brown's Interactive Tutorials. Now, tonight we're looking at strict liability, and of course, this is one of the topic under what was sent by CAPE and many others. Please be on the lookout for part 2 of this session. Now, what is strict liability in tort? In some torts, the defendant is liable even though the damage to the plaintiff occurred without intention or negligence on the defendant's part. These are usually called torts of strict liability. Two of the most salient areas are possession of certain animals and abnormally dangerous activities. Examples are liability for dangerous animals and liability in Rylands and Fletcher rule. Now, what are the requirements for a successful claim? Proof of injury must be shown by the plaintiff. The plaintiff must prove that the defendant's actions caused the injury. The plaintiff must show that the defendant's activities were unreasonably hazardous. Now, let us look at Rylands and Fletcher. Traditionally, the rule in Rylands and Fletcher has been regarded as a rule of strict liability. Liability is strict in cases where the defendant is liable for damage caused by his act, irrespective of any fault on his part, or as it has been expressed, where a man acts at his peril and is responsible for accidental harm, independently of the existence of either wrongful intention or negligence. Now, the person who, for his own purposes and in the course of a non-natural user of the land, brings onto his land and collects and keeps there anything likely to do mischief if it escapes, must keep it at his peril, and if he does not do so, is prima facie answerable for all damage which is the natural consequence of the escape. And this was highlighted by Justice Blackburn in the case Rylands versus Fletcher. Now, do you remember in Unit 1 where it is said that strict liability is where your mens rea is presumed? Why is this so? Now, usually, especially in Unit 1, a lot of the strict liability offenses were statutory in nature. And so, in essence, your actus reus, your actions would have deemed you liable, regardless of the fact that you didn't have that direct intention or that mens rea, which would have caused you to be guilty for other offenses. So with strict liability, they're saying you don't need to be negligent or you don't have to have the intention, but your actions will bring that liability. Now let us look at Rylands and Fletcher in more depth. So based on the definition, it must be a dangerous thing. So something dangerous. And according to the rule, the liability for the escape of things from one's land arises only when the thing collected was a dangerous thing. So in Rylands and Fletcher, the thing was large water body, which was a reservoir. And the rule also applied to gas, electricity, vibration, sewage, explosive, etc. So it must be something dangerous that you bring onto the land that is likely to escape. Then let us look at escape. For the rule in Rylands and Fletcher to apply, it is also essential that the thing causing the damage must escape to the area outside the occupation and control of the defendant. In other words, it must move from the defendant's land to someone else's land. The case of Reeds versus Lyons and Company is an example of no escape and hence no liability. In this case, the plaintiff was an employee in the defendant's ammunition factory while she was performing her duties inside the defendant's premises. A shell which was being manufactured there exploded and she was injured. There was no evidence of negligence on the part of the defendant, and it was held that the defendant was not liable because there was no escape of the thing outside the defendant's premises. So the rule of Rylands and Fletcher did not apply in the case. Now, foreseeability is very important as well. Foreseeability asks how likely it was that a person could have anticipated the potential or actual result of their actions. And this was highlighted in the case of Cambridge Water and Company, Eastern Counties Leather. Now, this company, Eastern Counties Leather Company, they were using a chemical. And of course, over a period of time, the chemical spilled and seeped through the cracks. And of course, went underground and contaminated the water company's tanks. Now, they brought them to court, and based on the length of time and based on, let's say, the small amount of chemical that would have spilled, then the courts found that there was no foreseeability in that regards, and so they were not found guilty. Even though the chemical was dangerous, and even though the chemical escaped, one of the elements was foreseeability. And so because there wasn't any foresight of this chemical escaping to cause that type of harm, then they weren't found guilty. Non-natural user is another element that you have to look at, and the word natural is used in two distinct senses. In this tort, first, it means that which exists in or by nature and is not artificial. Thus, as we have seen, there is no liability for an escape of things naturally on the land, such as rocks. It must be some special use bringing with it increased danger to others, and must not merely be the ordinary use of land or such a use as it's proper for the general benefit of the community. All right, so non-natural, it means if there was a pond on the property and that pond overflowed, and the water that was in the pond went onto another person's property, then the rule in Rylands and Fletcher would not stick because the pond was there naturally. So what they're saying is that it must be a non-natural user, right? It's artificial. So if now you decide to, there's regular land, and you decide to build a tank, and then you bring water and you fill that tank up, and that tank was not built properly and it started to leak and the water seep into someone else's property and causes damage, then that is an unnatural use of the land. All right, and so you can look at the case of Shandat and Reynolds, Diana Mines Limited, and Ricards and Lothan. Now, what are the exceptions to your strict rule of strict liability? One, an act of God. And this was highlighted in Nichols and Marsland. Another is consent of the plaintiff. Another is act of a third party, statutory authority, and plaintiff's own default. Now let's take a look at liabilities for animal. Now, cattle trespass is a strict liability offense. So if I am the owner of an animal in which by law the right of property can exist, I am bound to take care that it does not stray onto the land of my neighbor. And I am liable for any trespass it may commit and for the ordinary consequences of that trespass. Whether or not the escape of the animal is due to my negligence is altogether immaterial. And that was highlighted by Justice Williams in the case of Cox and Burbage. You can also look at East Coast Estates versus Singh, and this was where strict liability for the trespass and damages caused by cattle, right? So it was found that there was strict liability for trespass and damages caused by cattle. However, there is a statutory defense for that strict liability. And this was highlighted in Section 4 of the Trespass Act of Jamaica. It provides a defense for the owner of trespassing livestock who has properly fenced his land. You can also look at cattle trespass from the highway, especially if they were there lawfully. And you can look at the case of Tillett versus Ward in that regards. Now, we have liability for animals continued, where you have liability for dangerous animals. And of course, this is the scienter. Now, there is strict liability for damages caused by animals that are deemed naturally dangerous. And these, the Latin term is feri naturae, such as lions, gorillas, elephants, etc. The liability is absolute, except for acts of God or circumstances beyond the control of the defendant, or action of a party for which the defendant is not responsible under the law. You can look at the case of Behrens and Bertram Mills Circus, and you can also look at this Jamaican case, McIntosh versus McIntosh. Now, another category of animals would be your Mansutae naturae, and they're naturally tame, harmless, and most domesticated animals. Now, in order to highlight the whole liability for animals, you can also look at the Dogs Liability for Attacks Act 2020, and this is the Jamaican Act. It was amended in 2020. All right, so another topic that was sent was vicarious liability. And of course, this is just a part of it. Part 2, the other part of vicarious liability will be coming in part 2. Now, we want to know what it relates to strict liability and if it can be found in vicarious liability. Well, to be honest, a vicarious liability to an extent is strict. And so we want to kind of highlight that a bit. Now, liability that a supervisory party, such as an employer, bears for the actionable conduct of a subordinate or associate, such as an employee, is based on the relationship between the two parties. So in other words, there is an imposition of liability on one person for negligence, fraud, or mistake of another affecting a third party. The employer is liable for the employee's negligence in the scope of employment. Now, the employer of an independent contractor will be liable where the contractor commits a tort of strict liability, such as under the rule of Rylands and Fletcher, or under liability for dangerous animals. So let's say, for example, the employer did instruct the independent contractor to commit a tort. Then, of course, he would be found strictly liable for that independent contractor's behavior. All right, so in all, we will see you again for part 2 of this Escape Law Unit 2, 2022 exam broad topics. See you then.